Hey everybody, I'm Greg Siskind. Welcome to not our first live stream. We've done many of these, but it's been a while since we've done them, and we're back. We kind of got into this habit when Trump came into office 8 years ago. And we decided that it was probably time to, what was it, 8 years? Yeah, 8 years. Time to resume. So I'm Greg Siskind. I am one of the lawyers at Siskind Susser. I am joined tonight by colleagues Ari Sauer and Lynn Susser. Uh, Hopefully, you'll be able to figure out who's who. Um, and we're going to talk tonight about what everybody's talking about, which is the big immigration changes that have been happening. And they didn't just start Monday. We saw a flurry of changes that started before that. So the way we are going to deal tonight is we are going to first tell you about the last minute things that Joe Biden did in the weeks leading up to his departure, because there were kind of a flurry of immigration activities. And then we're going to talk about the Trump stuff, the Trump executive orders. There was a bill that was passed in Congress today. That's going to be the first bill that President Trump signs, and then we'll answer questions for you as well. So if you have questions, how you ask those questions depends on which platform you're watching us in. And right now I see that there's almost 300 of you here. But what you'll do is, if you're watching us on YouTube, post a comment on YouTube. We'll see it. Post a comment if you're seeing this on X/Twitter, if you're seeing this on LinkedIn. So that's how you ask us the questions, is just post the question as a comment in whatever platform you're using. We're using the wonderful platform StreamYard, which I've been using for several years, and we see all your comments from all these platforms all in one place on there. So once we see them, we'll kind of dig through. But let's go ahead and get started. So Lynn, we've sort of been jerked in two different they weren't all great, but we saw it was oh, this is great. This is nice. This is nice. These things that Biden, these little gifts from President Biden before he left office. Let's talk about a couple of those. So a lot of the people that follow me on these platforms and follow the firm on these platforms are here on work visas, and a lot of them are here on H-1B visas or are pursuing permanent residency through employment. So there was one really significant one, and there were several, but there was one really significant regulation called the H-1B modernization rule that went into effect Friday, and it was timed that way for a reason, so that it would be final and enforced before the new administration could stop it. But why don't you tell us about some of the things that the H-1B rule change, since that's the law. That's the law right now, and then we can talk a little bit about whether the new administration can fight those changes. But why don't you talk about what sort of some of the highlights for what we're going to see in there?
Okay, sure. Hi, everybody. I'm Lynn Susser, and my practice primarily focuses on employment-based immigration. I represent a lot of companies, big and small, and so we do lots of H-1Bs. So yeah, the rule what it does actually is codify several things that were the policy of USCIS already, but puts them in a form that it will be harder for the new administration to undo. So one of the big things that it does is it codifies a policy called deference. And what deference is it's a policy that basically says that USCIS, when adjudicating something like an H-1B extension, has to respect the fact that it was previously approved. So if there's no material change, and there's nothing to suggest that there was an error made the first time, then the renewal or the extension should be rather pro forma. So, and deference applies not only in the H-1B context, but for all different kinds of petitions that immigration approves. So that was super important, and it was something that was a longstanding policy of immigration for many, many years, and then the first Trump administration got rid of it. So the Biden administration brought it back, and now has made it part of a regulation.
Right. So it's going to be it's a lot harder for them to overturn something that was previously approved without it showing that something really dramatic has changed. They can't just to say, we
Right.
don't like the earlier decision.
That's right, because one of the things that happened during the first Trump administration is that they were treating every petition, every H-1B extension, every L extension as if it was the first time the person had applied. So this streamlines things. The next thing it did was it broadened the definition of specialty occupation in a way that really isn't that different from what's going on right now. But specialty occupation, as you know, is the definition of an H-1B is that they have to be working in a specialty occupation, which is defined historically as a job that requires a relevant bachelor's degree. And what they did was in this rule is they sort of broadened the definition to say that it can be a range of relevant degrees. It doesn't have to be one degree, and that you just have to show a logical connection to the job. So that was, and that is actually how it's been applied in all administrations other than the first Trump administration. So that was good. Another thing it did was it extended cap gap. So for those people who are selected each year in the H-1B lottery that are on OPT, if their OPT expires in the summer, then there's something called cap gap, which would keep them work authorized from the end of their OPT, from the date their OPT expired during the summer until their H-1B started on 10/1. And what cap gap did is what the modernization rule did is it extended cap gap to April 1st. So basically that means that even if the petition is not approved, if the H-1B petition is not approved by 10/1, the person can continue to work after 10/1 on their OPT. It also created or now allows for flexible start dates on cap petitions. So historically for H-1B lottery petitions, they had to have a 10/1 start date. And what this did was it basically said that they don't have to have a 10/1 start date. They just have to have a date that's within 6 months of the date of filing. Did a couple of other things. It made some changes to third-party placement H-1Bs, which I won't go into in a lot of detail right now, but basically what it does is it differentiated between, so third-party placement, like staffing agencies, or they can be other things besides that. But one of the areas that really came under attack during the last Trump administration was IT staffing companies. So basically companies that were placing H-1Bs at third-party work sites. And what this does is it sort of, it differentiated between staffing, which is basically where you're providing workers to another company, and those workers are sort of doing the job that company needs them to do, as opposed to providing services. And so what it says is that now they're going to look at the requirements of the job at that specific employer. So if you're replacing a third-party H-1B at a specific staffing location, let's say company A, then they're going to want to see company A's definition or job description for that job to see what they consider to be the minimum requirements and the degree requirements.
Lynn, can you say something about entrepreneurs? Because I know that, especially for a lot of people that are in the backlogs, this is one of the, for a lot of people, they're inner entrepreneurs, but they're kind of stuck in these H-1B positions for years and years.
Yeah.
There was some good news on that. So can you tell us a little about that?
Sure. Yeah. So one of the things it did, it simplified somewhat the qualifications for entrepreneurs to file H-1Bs basically for themselves. So for companies that they may own more than 50% of, and it broadened the ability to define what they're doing. So it basically says that entrepreneurs that are working for companies that they own, or that they're the, say, founders or directors of, that they are allowed to perform some non-specialty occupation work as long as that work is directly related to directing the company. And that was important because the requirement of showing a specialty occupation makes us, very narrowly defined jobs, which isn't always,
Great. And all right, so that was a H-1B rule. I'll just flag that there were some major changes to H-2B and H-2As through another rule. I'm not getting into that at all because I don't think most of the people probably watching tonight are in the H-2A or H-2B programs. But one important thing that it did was it removed that used to be restricted to certain countries. Well, certain countries were barred from using the H-2B program. That has been changed so that it's back to the old way where all countries are eligible. So that's all I'm going to say about that. I do think it's important to talk about sort of the TPS announcements that came last week, as well as one for deferred and forced departure. So can you explain what happened there?
Yeah, sure. So TPS, or temporary protected status, is relief that's often given to people from countries that they are unable to return to, either because there's a war or there was some kind of terrible natural disaster. Anyway, there are many countries that have been on the TPS list for years. And what happens is TPS is granted in 18-month increments. And there were 4 countries, Venezuela, El Salvador, Ukraine, and Sudan, who would have been up for extensions a little bit later this year. And the Biden administration went ahead and did the extensions. So basically making it possible for all those people from those countries to start re-registering. And then the deferred enforced departure is sort of a similar kind of benefit for people from Hong Kong.
Yeah. So, and we don't know why they all weren't done, but those 5 were. So hopefully, at least for the people that are in that group, that's going to give them some extra time to get their situations figured out. Okay. And Ari, there were some significant changes to the USCIS policy manual in the O1 and the National Interest Waiver Program. So, without getting too far into the weeds for people that don't know that much about those programs, can you just give a quick overview of what changed at the last minute there? It's not as happy, I think, in the NIW context as the other situations, but tell us what people need to know.
Sure. Okay. So for the O1 policy changes, for the most part, these were positive changes. So one change, and some of it was really a clarification of what they were already doing. So the first thing they have is that they've clarified that it can be an owner of the company, that if you can own the company and that company can sponsor you as long as it is a separate legal entity. So that's a clarification that's very helpful in the O1 context. Also, when there's some clarification as far as when it comes to we're talking about awards, people who are qualified based on awards. They clarified that those awards don't have to be received at an advanced stage of the beneficiary's career, so they can be from earlier on in their career. And then there's some additional explanations, examples of what types of documentation can be shown for original contribution. So, for example, patents or license, commercial use of the beneficiary's work, contributions to software repositories, and letters from interested government authorities. And then there was clarification on the 1-year extension versus the 3-year extension. And there was explanation that that you could get a 3-year extension on your O, even with the same company, where it is based on a new event or activity. And then there are examples of, this was very helpful, examples of someone transitioning from careers. So the examples they give, for example, are an athlete becoming a coach, or a STEM professor.
That's been a big problem for a lot of years with the O1 and the EB1 categories of that kind of change. So that's good.
Yeah, or STEM professor, academic researcher becoming working for a private company, or an engineer starting a technology company, or a dancer becoming a dance teacher. So that's very helpful that they've clarified that.
So what was the bad? So I hinted there was some bad news on national interest waivers.
So the bad news on national interest waiver is that the clarification that they gave seems to create a requirement that the degree that the person has is specifically needed for that occupation, or typically needed for that occupation. That was not a requirement that they had previously. And so that may create a situation where someone who was previously eligible for national interest waiver may have a hard time showing that their degree is one that's typically required, especially the advanced degree is typically required for that occupation.
Right. So that's not great news. For the category has been really popular in the last couple of years, national interest waivers, because of the AAO Danisar decision a few years back. and backlogs and all kinds of other reasons why people pursued that. And it seems like the agency, USCIS, was trying to figure out a way to cut the numbers of applications that were being filed. Unfortunately, they did it kind of in a ham-fisted way. And I dare say I think that it's probably going to result in some litigation because the statute doesn't actually say that the profession has to require an advanced degree. It just says it has to be a profession and the person applying has to have an advanced degree or 10 years experience. That's a big difference from saying that the job itself, because there are lots of jobs that may require a bachelor's degree, but there happen to be a lot of people in the field who have advanced degrees that go into that. So it might be somebody who has an MBA and in addition to their bachelor's degree in the substantive field that they're in. Anyway, so stay tuned on that. So we wanted to get that out of the way. And I did want to also mention that, as people have asked, well, can't Trump just basically delete all those things that were just done? And it's not so easy for a couple reasons. And then we're going to get into the Trump stuff in a minute. But for example, on rules that have gone properly through the rulemaking process, the only way that an agency can undo a rule is basically to go through new rulemaking and start all over. And that's a long, convoluted, very expensive, very difficult process for an agency to do. Now, it's not to say the Trump administration won't try and do that, but they usually have to also show why the rule itself that they're replacing was inadequate. There's also something called the Congressional Review Act, where Congress can actually undo with passing a bill that basically says, we don't like that regulations, stop it. And that is very unlikely as well. And that's actually where people forget that when Trump got elected in 2016, he also got the House and the Senate by narrow majorities. And there were rules that were pushed through at the tail end of the Obama administration, but nothing in the immigration space got overturned by the Congressional Review Act. And I'm fairly doubtful that will happen here. But anyway, that's that. There's also a couple other things to note. One is there was a Supreme Court decision a couple of months ago that was really cheered by a lot of people in the conservative wing of America. And it overturned a Supreme Court case from, I remember reading in law school, called Chevron. And the Chevron case from the 1970s basically gave federal agencies a lot of power to basically take their interpretations of the statute and kind of run with it and do lots of things that weren't really that clearly spelled out in what Congress passed, but the agency argued was consistent with the sort of the will of Congress, even if it wasn't specifically spelled out. Loper Bright was a case from the last session of the Supreme Court. Or was it earlier? Well, we're still in this session, but it was from the last one. And Loper Bright is a case that overturned Chevron, and now it's a lot harder for an agency to issue regulations that don't really clearly track with the statute. That's not to say that they can't fill in the gaps, but it gives judges a whole lot more power to overturn a regulation that that an agency has passed, including the immigration agencies. This was largely pushed by conservatives because they didn't like environmental regulations, they didn't like financial regulations. And so, it cuts both ways. In the case of immigration, it's probably fairly helpful for people that are fighting the Trump administration and planning on suing on all these executive orders we're about to talk to because of that decision. So that's one, really important development that's different than the last time. The other thing is sort of more broadly, when Trump came in 2016, a lot of people didn't really know how to sue. Immigration lawyers, and it's not to say immigration lawyers never filed appeals and went to federal court and did all kinds of, fought in all kinds of ways, but litigation really bloomed during the Trump administration. And a lot of people learned a lot. They sued the Biden administration quite a bit as well. And a lot of you have seen me on my live streams with my friends Chuck Cook and Jesse Bless and Aaron Hall from Impact Litigation. and we talk about litigation every week ourselves, and we've been talking for months about like what are the issues we're going to sue the administration on. And I can assure you that there will be a lot of lawsuits on a lot of issues, some of which I'll mention this evening. But I think that's this is a good place to probably turn right now to this flurry of executive orders that we've just seen. And I guess if there was one kind of theme I would like to leave people with is like, don't panic. Right now they've said this is a shock and awe period where they're trying right now to have as much. They would like people to get scared and run away, leave the U.S. and that will achieve their goals without actually having to do the things that they want to do that they probably can't do because they're not legal on there.
Because
So
they don't have the money.
Right. They don't have the money.
They don't have the money. So people self-supporting would be doing them a big favor.
And there's a lot of there's a lot of reasons why a lot of these things that we're going to be talking about tonight probably are not going to ever become reality. And I'll start with the first of the ones that I know a lot of people here are worried about. I've already seen at least one question in the chat about that. And that is about the executive order. It was called, I love how they have these like, innocent sounding names for these things. Protecting the meaning and value of American citizenship. So this is the birthright citizenship executive order. When we sent a client alert out today, this was the one that we put first of all of them because it's the one that most people are really freaked out about. A lot of people thought that this was only going to apply to people out of status in the U.S. Lubna Kali from the Times of India, who I talk to often about immigration stuff, forecast correctly that this was going to go beyond that, and it was going to go into the non-immigrant space, which indeed it did. So this order, it basically, the easy way to think about it is, it says, if you don't have a permanent resident or a U.S. citizen biological parent, you don't have to have both, but you have to have at least one. The child is not considered to be a U.S. citizen at birth, which is something that is been for the entire history of the country. That's been the way it's been on there. Now, that being said, on there, it's supposed to go into effect in 30 days. So that doesn't affect anybody with children now. Those children, they're not coming to take their U.S. citizenship away. But it's supposed to go into. What happens to those children that are born in 30 days? We don't know. And we're going to be saying that a lot tonight. It's like, who knows on here? Because this was not written by people who are deep thinkers on consequences and on there. I'm sorry if there's anybody from the new administration watching, but you didn't actually say, are these children illegal at birth? Are you expected to get on an airplane when the child is like, as soon as the child pops out, are you supposed to run to the airport with your child and get on a plane out of the country to get them a visa and come back in? Like, no idea what their status is after they're born, whether they're going to be able to file a change to a status or what. So that is it seems like they kind of threw that part in there about non-immigrants. Also TPS, all the other categories are the same story. Lynn.
Yeah, I was just go back for a second to the birthright citizenship issue and point out that birthright citizenship is not something that just came up recently in some, as part of some order in an administration. It's part of the 14th Amendment to the Constitution. And
it's
generally,
like Civil War. It's part of the Civil War.
Right.
What the country fought.
It came about during the Civil War. It had been the law before that, but it wasn't clear because African American people were, children of slaves were being denied citizenship, and it became part of the 14th Amendment of the Constitution. And generally, lawyers at least understand that you can't make changes to the Constitution without having a constitutional amendment. And amending the Constitution is a complicated process that requires 2/3 of the states to actually ratify it. Like, first it has to be voted on by Congress, and then 2/3 of the states have to vote on it. So the idea that an executive order can just be written up and thrown out there, and is just very, very unrealistic. So I know that people are super worried about this. It's what I've gotten the most questions on today from clients who either had children recently or are about to have children. And the reality is already 3 lawsuits have been filed, one by the ACLU and 2 others in multiple courts in the United States. So
by 18 governors from different states filed
right,
another.
18 governors of 18 Democratic or 18 Democratic governors.
Sorry, and I just
Go
want to
ahead,
jump in and just explain kind of the arguments here. Someone asked the question, doesn't the 14th Amendment say that anyone born in U.S. soil is a naturalized citizen? And it does, except for it says that anyone born in the United States and subject to the jurisdiction thereof. So the president is arguing, the administration is arguing that someone who is here, that only U.S. citizens and green card holders are subject to the jurisdiction of the United States, which previously that section, up until now, that section I think has been held really to apply to either those who have diplomatic immunity, like a prince, a potentate, a ambassador, someone like that from another country that has diplomatic immunity. Their children are not considered citizens born, even if they're born in the U.S. under that. And also in invading armies, members of invading armies are not considered their children not considered citizens. I believe those are the only 2 situations so far that the courts have said that this applies for. Now, I will say in a number of the executive orders, the president does refer to certain undocumented immigrants as invaders. And my theory is that the logic of that is that they're going to, make the argument that under the invading army understanding of that undocumented immigrants are not subject to the jurisdiction. Let's say, just for argument's sake, that was a valid argument, which it shouldn't be. That still doesn't answer why, someone with an H-1B, why their child born in the U.S. is not a U.S. citizen. Certainly, if anyone in these categories committed a crime, they would go to jail and be subject to the laws of the United States. Unlike someone who has diplomatic immunity, that person would not be subject to those laws.
I'll tell you, Ari, there's another reason why I also think, people say, oh, it's like you've got all these conservatives on the Supreme Court. Isn't pretty much like anything like that Trump wants going to pass through with this court. And I will tell you why I think even this Supreme Court is not going to, first of all, I don't think the Supreme Court is going to buy these ridiculous arguments that the Trump administration is making. But there's another concept in American jurisprudence where the court has said really major decisions on major public policy events should not be done via executive order. That's not to say that they would, if Congress passed something like this, that they wouldn't, look at it differently. But I think that's going to be the out for the Supreme Court on why they are not going to go along with the Trump administration, saying that this is something that's too widespread and important to the fabric of who we are as a country, and we're not going to do it this particular way on there. So I think that's we already got a question from Colton. I'll put that here, who asked, do we expect an injunction before the order even goes into effect in 27 days? Yes, on there. So a judge can enter a temporary restraining order on this. That is what all these cases that have been filed, these 3 cases, are all asking for that. The judge will have emergency hearings, and I'm pretty sure that they're not going to have any trouble showing that this is urgent on here. There's a reason why they all picked courts in Massachusetts and New Hampshire to file in. That's a circuit that is considered to be one that's not likely to look favorably on this. and the judge is there. So we don't know, by the way, who the judge in the case is yet. We should know probably in the next day. Maybe it may be known already, but I haven't seen who the judges are in these cases yet. It's not a foregone conclusion that they're going to get, a judge appointed by Barack Obama or Joe Biden in these districts. It's just that tends to be what happens, where the judges in some districts, like, they hang in for a while until a Democratic president is in, and that's when they announce their retirement. That's why some districts are very Trumpy from the last go around, and that's why some jurisdictions, some circuits are very Democratic friendly because of that. Yeah, they're not Democrats or Republicans, the judges, but there just tends to be, if there tends to be sort of views of the world. So that's all I'll say on that. But I am actually quite optimistic that this is not ever going to actually happen. And I think the Trump administration knows that. Trump said a lot of times, we're going to try. I mean, he was never saying it's like, for sure this is going to happen. He was like, basically like, we're going to throw the spaghetti at the wall and see if it sticks on there. So that's the first one. We want to get that one out of the way. That's the one that seems to be causing a lot of panic. I would tell people, take a breath. And this is going to be one that I think we're going to be looking at and saying, it's like, remember when he tried to do that? On there. So I don't feel that's confident on others that we're going to get to, but on that one, I feel a little bit better. All right. So we had another order about called America First Trade Policy. And let's the America First Trade Policy, we were talking about it. We have an attorney meeting once a month at Siskind Susser. We're at all our attorneys around a big table today. We were having discussions on this. And this is the one that reminded us, I think, the most of the Buy American, Hire American executive order from the first Trump administration, which that one, for those who have been around in immigration a while, will remember that one was sort of the excuse of anything anti-employment immigration. That was the excuse that was given. It was this executive order saying every policy should be done from the perspective of, does this hurt U.S. workers? And that's in this America First Trade Policy. There is reference made to that concept again of U.S. workers being considered. So, Ari, I guess this one, so how does this play in? Because this is, it's ostensibly about trade agreements. How would this play into immigration if it does?
Yeah. So the Trump administration has not. The order doesn't specifically say what's going to happen with it, but it does say that they're going to review it and see what changes they want to do, if they want to continue with it. One of the major things this would affect is the TN non-immigrant visa. That is a visa for non-immigrant, temporary visa for non-immigrants from Canada or Mexico, that allows them to come to the U.S. in certain occupations. And we were discussing, because there's law, there's statute, there's regulations that the TN exists, but one of the ways that this would affect this is that the TN has the U.S.-Mexico Canada agreement has a list of professions that a TN can be given for, and by changing that list or removing that list, you can either make it more difficult to get TNs, less occupations that qualify, or I guess if they eliminate the list, then I guess that eliminates the visa. But then what does the statute or regulation mean? So,
right. Yeah, so that one is harder, I think, in some respects, because it's embedded already in the Immigration Nationality Act, like you were saying. And also we have these E1 and E2 treaties as well that have a lot of immigration provisions in there, and that's how we get the E1 and E2 visas for these treaty trader visas and these treaty investor. So, we don't know. This is a really vague rule. Lynn.
Yeah, I was just going to point out that it's ironic because, in his last campaign in 2016, he ran on improving NAFTA. And during the first Trump administration, NAFTA basically was overhauled and became this USMCA, treaty. So this treaty that he's talking about was actually negotiated by the previous Trump administration.
Yeah. Doesn't make a lot of sense, but something to keep an eye on as far as where we might see some action on a. And then last night when I was posting on LinkedIn, I was posting on some executive orders that on their surface don't really seem like they're about immigration, but are really could be about immigration. That was definitely one of them. There's another one that doesn't mention immigration anywhere in there, but could have some pretty major effects on it, and that is the hiring freeze executive order, which he did last time, and it reads almost exactly the same as he did last time. But we've got this 90-day now hold on hiring at federal agencies, I guess, except for there's certain, they're going to make some exceptions for some kind of national security or national interest types of things. But for the most part, most federal employees are covered, and agencies are also told you cannot just hire contractors to get around hiring directly. So we've got that. Lynn, why do we care about that in the immigration context?
We care about it because USCIS and the Department of Labor and the Department of State, the people who adjudicate visa applications, perms, labor certifications, and just, immigration petitions, are all now going to be impacted by an inability to hire. And right now there are already long processing times, and this probably will result in even longer processing times because it's an initial 90-day freeze, but then it says that if the director of, I think it's OMB, doesn't come up with a plan within 90 days, it's just going to be extended. And we know that means not only can they not hire new people, but they can't even backfill. So that means if people retire, if people leave, if people die, they can't be replaced. So there's already terrible processing times across the board. I'm sure that many of the people that are listening know that, right now, non-premium processed petitions are taking over 6 to 8 months. Perms are taking, 16 to 18 months from the time they're filed. So there's just a long backlog. And most likely there's also going to be a real delay in visa issuance.
Yeah. So don't blame your lawyer. Unfortunately, and actually, I feel bad for a lot of the folks at these government agencies because they're going, as much as possible to try and pick up the load while they're waiting for this order to end. But it's going to be tough on them as well. So,
and Greg, we were already seeing as of a couple of weeks ago, premium processed cases that were passing the 15 working days, right? And so once the agency misses that deadline, they automatically, they have to refund the fee, but the case itself automatically goes into the standard processing queue. And we know that that was already a problem for them. They were already so overloaded and understaffed that they were already not being able to adjudicate within the required period of time.
Yeah. So slow processing times are back. Not that they ever really went away, but they're about to get a lot worse.
They're going to get worse.
Yeah.
They had made a lot of progress in a lot of places in the in immigration processing, and especially in the last year or two. I still recommend to people, to the extent you can do things that don't take these agencies as much time, think about it, including electronic filing, which was not an option for the most part in 2017. It is an option now. So that's sort of a practical. Why does that matter? Because it's just less work from the of having to have people manually re-enter information in that you're sending on paper. Somebody actually from the government retypes all that into the computer, and it's we have seen that those cases go a lot faster than the normal paper filed applications. So that's one practical reason why you might want to think about that, and why lawyers that are on this who are suspicious about electronic filing or their systems, their case management systems don't really linked too well to electronic filing, it's probably still worth it to take a look at doing that. All right, let's
one of the areas, probably one of the areas where we're probably going to see big delays are things that are not where premium processing is not available, like EAD renewals and things like that.
Yeah, I'll give you something that's going to cause delays. The next executive order protecting the United States from foreign terrorists and other national security and public threats. And nobody likes a terrorist, so we're not. This is another one that kind of like the headline is like, who wouldn't agree with that? But this is the one that calls for extreme vetting and screening processes across. Now, we've gone through extreme vetting before with this last administration where they, were reading your Facebook posts and your Twitter and your Twitter posts and all that. That was sort of the thing the last time. But Ari, what do you think we're looking at on extreme vetting, and how long do you think that is going? What do you think that's going to do to how long processing times take? So tell us a little bit about what that means, extreme vetting.
Well, I mean, unfortunately, there isn't a detailed explanation of to what extreme vetting is, but
you know it when you see it.
Yeah, you know when you see it, right? Well, you know that it's going to take longer. That's what we know. So it's really going to be, and they seem to be wanting to apply it to more items, to expanding it to immigration benefits that didn't previously go through this extreme vetting. But really, it's just going to mean across the board longer times for adjustment of status and especially longer times for visa wait times.
Right. So, and also if you're from a country that in the past has experienced delays because, it's a country that doesn't have great relations with the United States, or it's a country that has a population that's on Trump's list of people that he doesn't consider his, his favorites on there. You could see even longer delays on there. I think, we've had a lot of people saying, "Is it safe to travel? Is it safe to travel? Should we be traveling?" And that's the one that if you have to apply for a visa, you need. I would minimize the instances when you're going to have to do that over the next 4 years, and I would also have conversations, with at least one difference between now and then is telecommuting. I mean, remote working is like a lot more of a reasonable option to people that were stuck outside the country, waiting on. And in the last Trump administration, a lot of those people lost their jobs. During COVID, when we saw this repeat itself, by that point, we had remote working becoming quite normal, and people, it wasn't great for people that were subject to the travel bans. From a practical point of view, it was a little bit easier. You may not have a choice. You may have to travel. You may have, a family member that's ill abroad or something. But I would say minimize travel as a general rule if you can. Now, we also, Lynn, and no, we didn't talk. This is a surprise question for you guys from me. Visa revalidation in the United States. Is that going to go bye-bye? Because that was a Biden initiative. I don't.
Automatic visa revalidation goes back. Well, automatic visa revalidation goes back many, many years, and it's a process. For those of you that don't know, it's a process by which people who travel only in North America, basically.
No, I'm sorry. I'm not talking about that. I'm talking about filing visa renewals by extensions.
Oh, okay. Because I was wondering,
you're talking about renewals.
Just to be clear, visa revalidation is not on the table as far as I've heard, and that was coming as okay. I was wondering that too because I was coming as surprised. No.
So that's one big difference between last.
Are you talking about getting a visa here in the United States?
He's talking about waiving appointments. Are you talking about waiving appointments?
No, I'm talking about getting your passport stamped in St. Louis with the State Department.
So that was a thing many, many years ago that used to be like back in the 90s. It was a thing where you could send your passports to the State Department in DC and they would give you your new visa here. That went away after 9/11. And the State Department brought it back as a sort of a pilot program last year where they did something like 10,000 visas as a sort of a trial to sort of get this program up and running because the Biden administration had decided to reinstate this program at the State Department. I haven't heard anything about it, but I would guess it's probably gone. But if it's not, because as of, just a few months ago, the State Department was taking the results of this pilot program that they did, and we're getting ready to expand it. So if that happens, it'll be awesome.
They hadn't.
But for right now, it's not available at all.
Yeah,
like in the moment,
they hadn't expanded it.
Right,
so
but I mean that. So if it does survive,
if it does survive, it'll be a good
great solution for this issue.
And even that was only available for people getting renewals in the same category, right?
Yes.
So if you were on an H-1B and you already had an H-1B visa issued at a consulate and you needed a new one, then you could apply through that program. So we'll have to see.
Right.
I want to just.
Yeah,
I
don't think I actually.
In regards to minimizing travel,
did we actually use that? Did we do that at the firm where we filed any of those? I don't know if we did on there. If any of our clients actually took advantage of that.
I don't think we did because it was very limited as to who could use it. It was very, very limited as to who could use it. But the other thing I would just mention is that, yeah. Well, I do think though that in regard to minimizing travel, if you don't have a valid visa right now, and traveling means that you have to go for visa stamping, if it's not urgent, I would hold off, because let's at least give it a few months and find out what they mean by extreme vetting. Figure out which countries they're going to target. If you're from a majority Muslim country and you don't need to go, really don't go, because those were the countries that they targeted last time. And they said it was because in those countries, the governments there themselves weren't doing enough vetting, right? And so I think that for the moment, as a caution, if you don't have to travel and you don't have a visa, I would stay home. If you have a valid visa and you don't need to go to the consulate, maybe there's less risk right now.
Well, yeah. and you're not,
but the other thing
you're not from a Muslim majority country.
Right. That's right.
What's going to happen is when they implement that, they're not going to give any warning. And if you're outside the U.S., your visa may become useless. But and to that, this executive order also discusses that the president does call on the Attorney General and the Secretary of Homeland Security to get together and within 60 days to deliver a report identifying countries that they deem warrant a partial or complete suspension of admission into the United States. What we're expecting is something similar to what we saw.
Let me tell you what my friend David Biricato had conversations with some insiders that were working on these executive orders, and he's heard that 12 countries are likely targets for travel bans. So you should expect basically the countries from the last go around. That would be your Middle Eastern countries and Venezuela and North Korea. But this time around, there could be some that we haven't been on the radar. So you don't want to be outside the country when one of those bans goes into effect. They have sort of, had there was some reference made in this in the executive order where they mentioned the 60 days to potentially trying to find people in the U.S. that entered and trying to remove them under one of the national emergency. They cite invasions and emergencies and all kinds of things that a lot of judges are probably going to be skeptical about. But that's, I would say, the main risk is people that are outside the country. When a travel ban goes into effect, they do tend to have exceptions for them, but it's just a royal pain to do that, and they don't always work, those exceptions. So I would keep that in mind. I will tell you one thing that we will definitely be suing on. If they try and bar visas from being issued and not just bar the entry of individuals, that's when we litigated multiple times in the Trump administration and the early Biden administration. And we won all those lawsuits at Impact. And we have a lot of good law on the books on that particular issue. So why do you need a visa if you can't get into the country? Because first of all, it makes them actually do the work. But second of all, they, in a lot of cases, if you have the visa, you can then potentially make the argument at a port of entry that you're in one of the exceptions because you have the visa. There's just there are reasons why that would want to happen. Also, when these bans get lifted, that you could enter immediately and you don't have to wait if you already have the visa in hand, as opposed to the rush that's going to happen after the ban gets lifted with people that apply at that point. Anyway, so that's the last thing I think we want to say about the travel bans. We have
Greg, could I just add one quick thing? There is language in that particular executive order that looks like it may be setting them up to use it for targeting foreign students and university faculty that engaged in on-campus protests. So we don't really know that for sure, but there is sort of language in there that looks like, they may be. So that's just another thing that you wouldn't want to be caught outside the United States if you were in that situation and potentially could be banned.
Agree. All right, let's keep moving on these orders, and we'll stick. We're not ending this at 8 p.m. We'll stick around a little bit longer because we haven't gotten to questions and we still have some things to cover. Refugees, the refugee program. I will just mention quickly. The Trump administration has suspended the refugee program, the same refugee program that the United States originated after World War II. To welcome survivors of the Holocaust. It was put into place so that wouldn't happen again. That was sort of part of the never again agenda of the Truman and the Eisenhower administrations that worked with the United Nations in putting that in place. And that is suspended. Now, he did that last time as well. He also said last time that they would consider. The president has a lot of authority on setting the number of refugees that are here. And so that's one that you can't really fight that one in court. He said that we've heard that they would consider up to 20,000 a year. Hopefully that'll be the case. I did hear from one of my good friends who's a lawyer who was, they had somebody that was basically about to fly out from Afghanistan and was coming in the refugee program, and, very upsetting. That those folks who have gone through all the vetting and all that are not here, are not coming very quickly. But fingers crossed that at least that program will resume at some point, maybe in a few months at a much smaller scale. But I'm not holding my breath. We basically went 4 years without refugee admissions from 2017 to 2021, and that looks like that's repeating itself. We haven't really talked that much about what everybody's talking about, which is the border and immigration enforcement. And we're not going to, I don't know that we have tons to add on that, except I'll just sort of mention some of the highlights or lowlights. That includes the military being used at the border. That started today. I had seen two figures that they were sending 1,000 troops. They were sending 1,500 troops. I'm sure that the military's super excited about being diverted from their actual job of protecting the country from real threats, now to having to basically play a part in this whole, this whole song and dance. But that's, there are a lot of other parts to it. Ari, the big one probably has to do with the. I'm not even sure. They kind of scatter these across multiple executive orders, but there is one that essentially ends asylum at the border, and maybe you can just mention a little bit about that, because that
was one of the most recent ones. Well, that was the protecting states from invasion or something like that was the name that was issued either this morning or last night. But it was basically says that anybody who, it seems to say that anybody who is involved with illegally entering or exiting the U.S. southern border is involved in this invasion.
They're invaders.
They call them invaders, and what it is saying is that they are no longer. Well, it seems to say they're no longer going to be issuing asylum to anyone who comes to the border to enter without documentation, or it also seems to say that anybody who has entered without documentation is not eligible to apply for asylum in the United States. And that one especially, I think, I don't think that, I mean, it's asylum is in the statute. So I don't know that he has the authority to say that someone who is otherwise eligible for asylum that is in the United States is not able to apply. But that is what this executive order is trying to say.
Expect a lot of litigation around that question. And, also there were in this same order, there was mention that they are going to be cracking down on the temporary protected status programs. So the ones that we just talked about extending, I think the Biden administration anticipated that was going to happen. We don't think that they are going.
That's actually in a different order, executive order, but that is covered. Yeah.
Well, the other thing that's affecting asylum seekers is that because of the programs that the Biden administration had put into effect, the one primary way that asylum seekers coming from the southern border had to apply for asylum was to make an appointment through this this CBP One app. Well, they shut that down already. So now they basically closed off any way for asylum applicants that are refugees coming to the southern border to apply as a practical matter.
Right. And that's kind of the irony here. So in this, they're using this travel ban statute 212F to justify excluding all of the invaders. They don't actually define who's an invader on there, and that's also, I think, going to make it interesting to see how they try and do that. And I don't think judges are going to be particularly happy about that. But that's that being said, all of these are people who are not actually in the country. They're in Mexico, and they've applied for appointments to ask for asylum in the United States. Now they're considered invaders because they actually got on a line and knocked on the door and say, "Please consider my application." Right. They didn't actually enter the country illegally, but that's who's being targeted with that language. It's curious. They have in the Ari, I guess it's the protecting.
All right, I just want to answer a question. There was a question if that includes withholding and Convention Against Torture application. My understanding, yeah. So those are all under Section 208 of the INA. That does appear from the
that's mentioned in the
executive order to include withholding and Convention Against Torture, which I think are all also under the same 208 section.
This executive order, Ari, and I'm not, I know this kind of cuts across a couple of the different orders, this whole thing, but parole in place, they make it very clear that parole in place programs from the 8 countries that have that.
Yeah. I mean, the one that does the most things is that protecting the American people against invasion. That's the executive order that you're talking about. With the
sort of a catch-all for a lot of things.
It is. It's got a lot of different things they did.
Yeah, there's threats to cities and states that are not fully cooperating with the Trump administration on their immigration agenda to withhold funding and today there was news that they're starting investigations at the Justice Department against cities that are absolutely complying 100% with the letter of the law. So I'm wondering, kind of like, investigate all you want, but it's not a crime or illegal to do a lot of the things that these cities want to do on there. And actually, that did not fare very well in Trump version 1 when they went after the so-called sanctuary cities. The judge shut that down on there, and I would expect they were going right back to that judge on there. So those are some of the changes there.
There's also some nasty language in there that has to do with, targeting nonprofits that service the undocumented community, that have any kind of like federal grants or anything clawing back money. there's language in there, requiring maximum compliance with DHS in regard to I-9 audits. So for those of you out there that own businesses, it's a good time to make sure all your I-9s are in order. We're expecting lots more I-9 audits.
Have a plan in place, employers, for ICE if they show up at your office. That's that's good policy. All right, let's apologize for that.
Well, and another thing I don't think we touched on yet is that the executive order seems to say that it does say that work authorization, EADs, employment authorization cards, are no longer going to be issued to undocumented immigrants. Right. So there are a lot of situations, a number of situations where someone who is an undocumented immigrant, although who is an undocumented immigrant is not clear either, because that's not a term defined by the INA. But the people that are deemed to be undocumented immigrants, apparently, they are not going to get these work authorization cards. And there are a number of situations, say, for example, someone who can be an undocumented immigrant but eligible for work authorization based on a pending green card application, I-45. This seems to imply that they are not going to issue work authorization cards to people in those situations, although we're going to have to see who they deem an undocumented immigrant under their definitions.
Right. The language of that section is very, very broad, and they're going to have to wait till they define it, because it could mean anything from people on orders of supervision. It could be people who, we don't even know, are they going to consider that DACA people to be undocumented, or people on TPS, or, people waiting on asylum applications to be adjudicated. It's a very broad statement, and it's too soon to panic about it, because until they actually define what undocumented means, there's no way to know who that's really going to impact.
Yeah, I suspect probably what they're trying to go after are, the people who are in removal proceedings that are in these that have been.
That's right. That's possible. People with pending cancellation applications that have work authorization.
Yeah, so we have to wait and see kind of what they mean on that, but that's kind of a sleeper provision in the executive order that could come back to be problematic. All right, I want to move from the executive orders to this thing that just happened this afternoon around 4:00 Central Time. The House of Representatives passed Lack-and-Riley, which is the first bill that will be signed by President Trump. This is an immigration bill. It got a lot of Democrats voting for it, which was a little bit of a surprise. But it was it does a couple of things that are important. One is that it makes it a lot easier to detain people that have been arrested for crimes, even if they are innocent and didn't do them. It's based on suspicions and arrests, and not on actual you're getting your day in court.
Right, it's not about convictions.
Right, which is kind of scary, because a lot of people, could end up in the, with accusations against them and retaliations and that kind of thing, where, you just point the finger at somebody and say, and say that they did this, they're completely innocent. Well, they're not just, getting arrested and then getting bail and getting out. They have to be detained the entire time that they're waiting to be able to prove their innocence. So very scary stuff there. And then the other part of that, which raises a lot of constitutional questions, that part might have some constitutional questions as well. The other one is it allows states to sue the federal government if they make a claim that a particular country's immigrants are causing harm to the people of their state. So if you get some, governor who decides that immigrants from, I don't know, some random Monaco, Bahamas, whatever, on there, that they are, the Bahamians are taking all the jobs in their state. They could sue, and then a judge could order in theory, a judge could order all Bahamian immigration to stop on there. That is likely unconstitutional because the Constitution actually says only Congress can regulate immigration. And this is Congress essentially delegating huge authority to states to have a say over U.S. immigration law. So a lot of people some of the Democrats that were interviewed on, they said, well, we signed it for the criminal immigration stuff. We're pretty sure that they are going to find the rest of it unconstitutional. It's like, well, hope you're right on there. So that was that's the first sort of major news that's beyond the executive orders. We do actually, I did want to mention, we do have some appointments, and somebody actually asked about USCIS. We have an acting director of USCIS for now. Her name is Jennifer Higgins. She's a career employee, and that's not that unusual. That tends to be what happens when there's a change of party after an election, where until they get their people confirmed, it will be career people who are taking the helm. The exception is that when that career person is actually taking the political appointment, which is happening at ICE, one of there's somebody who's currently an official at ICE who's being appointed as the head of the agency. So that person's not going to change. But CBP is the same story. They have a career person at CBP in charge, and they haven't named yet who they have in mind. Chrissy Nome is the named DHS secretary. I am not anticipating that she's going to get a lot of opposition, despite her reputation with America's dog owners. And we do have a new Secretary of State. He's already been confirmed, Marco Rubio. I consider that a good appointment. Probably about as good as we were going to get for Secretary of State if you think our immigration system is important to the country. Marco Rubio has a long career, and he sponsored immigration reform bills in the past that were pretty good. Now, I know that he's working for somebody else, and he has to toe the line for the administration, but I consider that to be a good appointment. So that's just my personal view. I'm trying to think. Tom Homan is sort of the immigration czar. There's one person who's not actually going to have a position that requires confirmation, and that's Mr. Stephen Miller, who is the deputy chief of staff. And the president doesn't, he gets to pick his own staff in the White House. And Stephen Miller is at a pretty high ranking level. So we will see. And I've talked a lot on social media sort of about the war back and forth between Elon Musk and Stephen Miller and who's going to win and all that. And we're not going to get into that tonight because the proof will be in the pudding. We'll see what stuff actually gets introduced. It may, look, there's not a lot on the employment immigration side that got put into these executive orders. Maybe that is because, the billionaires in Silicon Valley had something to say about it. On the other hand, this is just getting started. So, we'll ask me in a few weeks or a few months about that. So that's that. I think that we might be at the end of a list of things that we wanted to cover right now. And Lynn, am I forgetting anything? Ari, am I forgetting anything that we want to cover before we got some questions?
I don't think there's anything that we wanted to, no, I don't think so right now. I think that we've hit all the high points. One of the things I just wanted to point out, though, when thinking about employment-based immigration, one of the main big things that they did during the last administration was they just slowed everything down, right? They required adjustment of, every person applying for adjustment of status to be interviewed. And they did things like that they're free to do. Those are just policy administrative things that they can do with, at will. And those are the things I think that Stephen Miller and that crowd are really good at there. And what that accomplished was basically overwhelming the local field offices to the point that everything else just came to a grinding halt. And so, there was a question in the chat here that asked about whether or not employment-based adjustments were at risk. I don't think they're at risk in the sense that, at least not yet, based on anything we've seen yet, I don't think they're at risk of being denied, but I do think that things are going to just slow down considerably. And we haven't seen those policies yet, but I don't think we'll see those things happen until there's a USCIS director.
One thing we saw the last time, which we haven't heard anything about, that affected employment immigration a lot, were those interviews for I-140 interviews that they were doing at local USCIS offices all over the country.
Well, I-485 interviews, that was the main thing.
Right, but it was they were the employment-based.
The employment-based adjustments, right?
Employment-based I-140 based adjustments, and usually the issues they were getting into were the underlying were on the I-140s on there. That hasn't been mentioned as coming back. But
that's the kind of thing that I don't think we're going to see until there's a director. Right. But I think that that's the kind of thing that will slow the process down. And what happens is because keeping in mind that local field offices right now only interview primarily spouse-based adjustments and naturalization applications and very few other things. So if now they have to interview every single person who's applied for a green card, it's going to just slow down everything, including naturalization and all kinds of other things.
It didn't really cause an increase in denials.
No, just a slowdown.
It just slowed everything down.
Yeah.
Oh, by the way, I'm putting up the disclaimer. So for everybody on here, it's like, talk to your lawyer about your specific. We'll talk generally on there about questions that apply to a lot of people, but that's our little disclaimer.
I always want to say that there's a question in this chat box that says, "Do I need to properly comply with LCA postings?" And the answer is yes. You should always be doing that anyway. That's
Yes. Obey the law. All right. So this question was whether we were going to see any changes to naturalization. And then it's a good question about this registry. We didn't even talk about that in the executive order, sort of this bringing back of this registration. They kind of hint at it in the executive order that they're going to use that to go after undocumented folks who don't come in and register on some registry. But we don't actually have that right now. So it's not really clear what they're talking about there. But on naturalizations, the one thing that they seem to, the last time the big thing that I think affected naturalizations a lot were the interviews. They added, they messed around with the way the questions were asked. They made a lot more of them on there.
That also was affected by the slowdown of everything else, of them having to prioritize because of retrogression and because of the quotas on employment-based immigration. The field offices had to prioritize those cases in order to use up all the visas during the fiscal year. And as a result, everything else got pushed to the side, which made naturalization processing just much, much longer.
Yeah,
the other thing they did last time around in regard to naturalizations that has really never been a thing except for during those 4 years is USCIS was digging through old naturalization files, looking for reasons to revoke naturalization. Yeah, looking for reasons to revoke. And I don't think that overall they came up with that many, but it was it was definitely
I bet you that's coming back.
And somebody asked the question here: any changes to H-4 EAD? Not yet, but we know that that's one of the things that this administration just hates. So eventually, that may be targeted. It's another thing I think we're not going to probably hear about until there's a director.
Yeah. All right. So this is the question that Aaron asked, and we know Aaron. Hi, Aaron. Asked, and we talked about this actually in our attorney meeting today on there. And there's I'm going to post. I posted this on LinkedIn from another AILA lawyer, is a friend of mine, that AILA put out a Know Your Rights memo that's pretty detailed about answering doors, answering questions. The long and short of it is that if there's a real judicial warrant that allows somebody to enter, you have to let them in. On there, but an ICE warrant, I think, Ari, that's what that is not the same thing. Right. And anyway, I'm going to repost that again on on a couple.
Also, there's a couple
ACLU.
of, Aaron, there's also a really good article on the ACLU website about
Right.
this that goes through it. First, it details what you have to do if they come to your house, but then below that, there's a whole section on what you have to do if you're the employer and they've come to your place of employment, or you're a school, or you're a church. So look at the ACLU site. If you want,
Greg,
send
are
me an
you able to
email and
share
I can send you that link.
I put the link in our private chat. If you want to share that with.
Yeah. Okay. Hang on a second.
That's the ACLU chat link.
Okay, I can do that.
Yeah.
If you want, yeah, I can also here. Let me
I
grab
think
the
I can
ALO,
do it. I think I can do it. Yeah, here it is.
the ALO one also.
There you go. Yeah, I mean, the nice thing about this is, like I said, it goes through and it separates, sort of talks first about individuals, and basically says, that they shouldn't open the door, because most ICE warrants are not judicial warrants. They're not signed by a judge, and therefore they're really not enforceable.
I mean, it's important. Definitely don't open the door unless you've seen the warrant. Don't just because it says warrant doesn't mean it's a actual warrant, judicial warrant. It has to be signed by the judge, and it also has to be for the correct address, and it also has to be naming someone who's actually lives in the residence, or is, I don't know if it's lives in the residence or physically in the residence at the time. Before you open it. So, it may be that they, have a warrant, but the warrant's got the wrong address on it. That's not.
Yeah, I mean, Aaron was also mentioning something that was distressing, that I posted about as well, which is the rescission of a 2011 ICE memo that prohibited ICE from engaging in enforcement activities at certain sensitive locations, and that's schools and hospitals and churches, and certain places that it would be, that would be deemed to be off limits. They're not now. And so I would say that, that communities need to basically educate themselves on what activities they can and can't do on there. But that is something that I'm hoping that ICE, exercises some restraint, even though they have this, have this memo. I'm guessing that, a lot of folks at ICE are going to think long and hard about what the implications would be if they get aggressive in doing that, and really only use that change in the most sparing of circumstances where they feel like they have no other choice on there, as opposed to something that's just going to, be designed, I think, for what the administration wants, which is just to scare people. And that's, probably why they announced that on the first day. But anyway, that is that's what, what I have to say about, as far as about ICE enforcement. Worksite raids are going to become a much bigger reality, though. Lynn already mentioned that earlier. We saw, some raids already happening in some locations that they seem like they're interested in the blue states in particular on there, and I expect to probably see more than that. However, these, ICE is already privately, before this Lack and Riley bill passed, they had already been circulating out saying, it's like, you are asking us to do a lot, Mr. President. Where's the money coming from? And we haven't really talked about that as being probably the biggest obstacle to his agenda, which all these things cost money. ICE raids cost money. I-9 audits cost money. Detaining hundreds of thousands of immigrants costs a lot of money on there. And at this point, they don't have the money and they don't have the people. Even if they had the money, it takes a long time to get the people together. So a lot of this right now is this shock and awe idea of like, let's make as much noise as possible, even though we don't actually have the means to do all the stuff that we're saying we're going to do, and get people to deport themselves as opposed to our having to do it on there. That is the intent. That is the intention.
Greg, can I jump in here and answer this question from David Castro, asking whether or not we think it's a risk for people traveling with already approved advanced parole, waiting on their employment-based adjustment application. So I think that there's two things to say here. One goes back to this issue of travel bans. Like, we need to wait and see like which countries are going to be impacted, because if you're out of the country and you need to come back and you're from a country that's subject to a travel ban, then I think you'll have problems. But that being said, other than that, I don't actually think it's a big risk to travel on advanced parole. The one thing that CBP has said consistently over the years is that they don't want to re-adjudicate advanced parole, and that it's USCIS's job to issue advanced parole documents. And if they think the person's eligible to travel on advanced parole, then so be it. So most people we've never had clients have issues coming back on advanced parole, other than, like I said, in the case of a travel ban, or a worldwide pandemic.
There was one good piece of news on advanced parole, by the way, that it was sort of a sleeper provision. So some people were amused when I was posting about Project 2025 after the election, and some of the ideas that were in this, which most of them are a lot of things that they're implementing in these executive orders. But they did actually have a little section, an idea on advanced parole, which kind of got a lot of people enthusiastic, which is the Heritage Foundation, which wrote Project 2025, would like to do away with advanced parole and just make it travel incident to status with an adjustment receipt, which is something I've actually been for years and years been posting saying, please do this. This is like a kind of a nonsense work waster on the part of a lot of people at USCIS that could be using those time resources for something a little bit more meaningful. All advanced parole applications get approved. It's just basically it's make work for thousands of examiners. And so hopefully that's something that's still going to be coming. I think Lynn's right as far as travel bans go. And I'm afraid that that's probably going to be something that we're going to be seeing for this entire administration, which is sort of randomly using Section 212F when it suits them to get back at a country that's, where some prime minister insulted President Trump over something, and then 2 days later we find out that there's a travel ban,
or some activity that the president doesn't agree with as well.
Yeah. So anyway, that's
the other place that this advanced parole coming up is in a separate question from Colton about whether or not we should advise we've been advising all of our DACA clients in particular to get advanced parole and travel, make a quick trip so that they'll have a legal entry in case they need it later to adjust status. Right. And
not all our DACA, the DACA clients who came in previously without inspection.
Right. And so, I think, Colton, for the moment, I'm tempted for my clients that could just make if they've just got advanced parole now for a very short period of time and they could just take it to go to Tijuana for the day and come back, I'm inclined to tell them to do it, because the right now, I think if there's a travel ban, it's not going to affect Mexico, at least not in the short run. I think eventually Mexicans are going to be infected in some way because of these crazy governors like in Texas. But I think I'm very tempted right now to let them make really quick trips if they can. And because the advantage of having the legal entry is huge. I don't know. I think we're going to have to all think about that and discuss the risks with our clients and let them make the final decision. But I've got the advanced parole. I don't know. I would be inclined to tell them to use it.
And I think
sooner rather than later.
I think based on previous experience, I think if DACA, if they go after DACA, it's going to be phased out. It's not going to be an immediate. We're going to take away benefits from people that already have it.
Right.
So if you already have advanced parole, I agree. If you haven't used it, use it quickly.
Use it quickly.
Use it quickly. Use it now.
Sometime in the next 60 days, use it.
Right.
Yeah.
And if you have it, they're only valid for a certain period of time anyways. But
no long trips, but a quick weekend in Mexico or afternoon in Tijuana is a good idea.
Yeah. And there was a question about what we expect for DACA. I don't remember who.
The first Trump administration tried to get rid of DACA, and there are still multiple ongoing cases trying to get rid of DACA. But for the moment, they're all stayed.
This is
right.
money.
Right. So for right now, people with DACA can still continue to renew. No new applicants are allowed, but that's been the case for a number of years already. And I agree with Ari. I don't think they're going to announce one day that everybody who's got DACA doesn't have it anymore. I think what's more likely to happen if they are able to do it is eventually they will stop issuing renewals, or they'll follow through with that,
Well, the
executive
courts are
order
going to
talks
the
about
courts are
EAD.
probably going to kill it first. I do
Right.
think that the Trump administration is going to probably try and figure out a way to trade DACA for other items on their agenda and try and get something through Congress and get some Democrats basically to sign off on some kind of compromise where they provide some kind of long-term status for DACA in exchange for their laundry list of things that are in these executive orders that are illegal that they would like to make legal through actions and through an act of Congress. So if I had to predict, that's probably where we're going to see change.
But I do think that within this executive order is probably what we're going to hear clarified is that no longer going to be issuing parole for DACA. Beneficiaries. I think that falls under the groups of people that
also,
they're not.
that happened in the last Trump administration.
Right.
That happened in the last Trump administration. They never made it a formal policy, but they just stopped approving them. They said that people, documentation of emergent need was just not good enough, and they just stopped issuing them.
So I think if you don't have a parole yet, DACA parole yet, I don't think you're getting it. If you have it, use it quickly. But I'll clarify. Use it. That's only, we're talking about people who previous entry was without inspection. If you've already used the DACA parole before, or if your original entry was with a visa and you overstayed, I would, be less likely to tell them to go out of the country.
Yeah, could I just comment on this very last question here from A.L. Aber? I think
this will be the last question.
Yeah, I think the question is that if your H-1B was approved based on the AC-21 provision that your perm had been pending for more than a year, but then at some point the perm is denied, does the H-1B cancel? So the answer is no. You get to use it till the end of whatever the period is, right? So if it's been approved through next year and before that year is over, your perm gets denied, you still get to use the rest of the time on the H-1B. If you have a valid stamp, but the perm is denied while I'm abroad. Right. No, you still get to, your H-1B is still valid for the period it's been approved. You just won't be able to get any further extensions. Though the one thing I would mention is that if you appeal that decision, it keeps it alive. So something to think about. Yeah,
and I would I just say we'll end there, but I did want to remind people we'll be back next week, and I'm not sure it's going to be me because I have some flying, but it'll be a couple of our lawyers. We'll tell you again about what we saw over the last week, and kind of keep you up to date on the progress in terms of or the lack of, what's the opposite of progress, on some of the changes that we're seeing. But we're going to try and do it at the same time each week, and basically let you guys know what's going on. But of course, follow us on our social channels. And in the meantime, I want to thank you all. We had a lot of this, probably more people on this live stream than anything I've ever done using this platform. I think we're at about 2,800 people right now. So thank you guys for watching, and hopefully you picked up some good information. All this will be available for views later for people that didn't catch this live. So tell your friends they can watch us on YouTube or LinkedIn or any of these places where you found us. This will be there. So we will see you next week.
Right. And before we leave, just want to remind everybody, this was general information. It was not meant to be, shouldn't be taken as legal information. Don't rely on it without speaking to your attorney. Hopefully a Siskind attorney, before you rely on any of this information.
Thank you, everybody, and we'll see you next week. Bye-bye.
Thanks, everyone.